Okay, in this lecture, we are going to begin talking about non-word marks and how exactly trademark law treats them. So, of course, we are awash in the world with any number of trademarks that are not words, things like the golden arches, the Mercedes-Benz logo, all kinds of logos. And so the question is, when are these things distinctive for trademark purposes? And so, there's a couple of things that trademark law does with these. Number one is to go ahead and try to apply the Abercrombie spectrum. And so take a look at a Nike swoosh. And when you look at that, what do you think? Is that something that you can think of as being fanciful or arbitrary, suggestive, descriptive, or generic? Are those categories that we normally think of in the context of word marks helpful for a symbol? Does the swoosh, suggest speed because it's streamlined, or it's a check mark and you have to know in context that the product is a sneaker to make that kind of suggestion or association with streamlining and speed? And I don't know, I mean, you consider marks in context, so I'm not saying that this isn't something that can be applied, but it's something that I personally have always found to be a little bit tricky and pretty much unhelpful for purposes of the question at hand. And so there's another test out there, the test from a case called Seabrook Foods, where a court is supposed to ask, is the shape or design a common or basic one? Is it unique or unusual in a particular field? Is it capable of creating a commercial impression distinct from the accompanying words? And or is it a refinement of a common ornamentation? And your mileage may vary, but to my mind, it's the third in that list I just recited that really counts. Is it a shape that's capable of creating a commercial impression distinct from any accompanying words? And what I think is helpful about it is it kind of puts the finger on what the issue actually is insofar as we are trying to determine whether or not a symbol is distinctive for trademark purposes. But of course, in answering the question, one kind of, that's the whole analysis. And how does one exactly determine whether the shape is capable of creating a commercial impression distinct from the accompanying words? And I don't know, your mileage may vary, but to my mind, this stuff is really in the eye of the beholder, and I'm not sure it's all that helpful to break things down to a test beyond, and the other parts of the test can be kind of helpful guideposts, this idea of whether it's a common shape or the like. But I think at the end of the day, this is kind of fact finder intuition. And the problem with that is that insofar as it may only be fact finder intuition, it may be a tricky thing to resist marks insofar as courts may require some kind of evidence that something is not functioning in a distinctive way, particularly when we're talking about the review of the Patent and Trademark Office if it refuses to register a particular mark. But in any case, inherently distinctive symbols and designs are registrable. Non-distinctive designs require secondary meaning, same as you might have with, same as is the case with word marks. And so, compare something like a yellow dot and a Chevrolet symbol. One maybe, under the Seabrook test, common shape versus something that maybe looks a little bit more novel or isn't a similar refinement of a common design. And you can, look to things like whether or not it's, common in the field. So, there is stuff that we can look to. What about something like, say, a smiley face? Is that registrable? Well, if you look at the Trademark Manual of Examining Procedure, you have a section that says the significance of the proposed mark is a factor to consider when determining whether ornamental matter serves a trademark function. Common expressions and symbols, for example, the peace symbol, a smiley face, or the phrase, have a nice day, are not normally perceived as marks. But then if you go and look on the trademark register, you will see that there are a number of smiley face marks. And indeed, if you actually look at the design search code manual, there's a specific code set aside for smiley faces. That's how frequently the Trademark Office gets these kinds of things for registration. So again, it's a tricky question. And the question is even trickier when you consider the interplay between features that may not be especially distinctive and those that are more distinctive. So take a look at the image on the screen for a proposed trademark for an orange flavored vodka. And so clearly, as a whole, this is something that is capable of performing a trademark function. You've got the name, you've got some graphics, you've got the stylized O, you've got some other graphical elements like the orange peel. Put them all together, sure, that's a trademark. That's not hard. But what about the O? The O standing alone in and of itself. Is that something that is going to be registrable? And in a case that went to the Second Circuit, the court said that the stylized O had sufficient shape and color stylization to render it slightly more than a linear representation. So it cleared the bar for being a distinctive trademark. That said, however, the court said the protection that it gets is necessarily thin. In other words, in a trademark infringement suit, there's an expectation that the trademark holder is not going to go after any old O in the marketplace and claim that it's likely to confuse consumers. Rather, it's supposed to be looking at O's that are very similar to the one that actually has trademark protection. So a similar kind of shape, similar kind of design, similar kind of shade of orange. And so note this issue that the court is assuming that if we are generous with allowing trademark protection in the first place, that is not going to be abused down the line in a trademark infringement suit. But of course, in many cases, the court or the trademark office or the entity that is recognizing trademark rights is not necessarily the entity that is going to be sitting in judgment of a potential infringement suit down the line. And so note we have this interplay of doctrines within trademark law. If we are generous with what may receive trademark protection on the front end, we have to be rigorous and careful on the back end that those trademark rights aren't leveraged to reach a lot of matter that is afield of the relatively narrow protection that was granted on the front end. And so an interesting question to keep in mind as we move on is your confidence level that trademark law is capable of this kind of thing.